Hi, everyone. Welcome to the Queen's Colloquium on Tax Law and Policy. And today we have a very special guest, Luiza. She's been doing tax law, international law, and human rights. So usually when we look at the literature and we try to look for a connection between tax and human rights, the focus is usually on taxpayer certainty on civil liberties. But Luisa is focusing on a connection that is often missed, which is a connection between a second generation of human rights, right? So economic and social rights and how tax may be relevant for ensuring that states are able to focus on these rights. And she's doing some very insightful work. So I'm very happy to have her here with us. And we also have two students who are going to be co-hosting Luisa today, Shivam and Mitch. And they're going to start in a moment. Just for those who are not familiar with the format, so the tax colloquium is integrated into our tax policy class. So this means that students enrolled in the class will have priority in asking questions. So after Luisa presents, the students enrolled in the class will ask their questions, and after that, we're going to open the floor to other participants. Yeah, so that's it from me. So maybe we can shift to Mitch or Shivam, whoever is starting.
Good morning, everybody. As Professor Ozai said, welcome to this morning's next installment of the Queen's Colloquium on Tax Law and Policy. Today, Luiza Leite de Queiroz will kindly present her work on human rights contours, time, and place within fiscal constellations. We're very eager to hear more about her novel analogy linking human rights and taxation. But while we gather virtually, let's acknowledge that Queens is situated on the traditional Anishinaabe and Haudenosaunee territory. We're grateful to be able to live and learn on these lands. Let us also recognize that our online setting connects us across many different Indigenous territories. Allow me to introduce Luiza Leite de Queiroz. She's a PhD candidate in the Faculty of Law at Vrije Universiteit, Amsterdam. Her research revolves around the intersecting topics of transnational tax justice and human rights. A member of the Brazilian bar, Ms. Queiroz is also a global scholar, completing her studies in law and international affairs from Brazil, Portugal, Ireland, and Germany. Finally, Luiza's experience in international development is based on her work for the German development agency GIZ in Zambia, as well as on a development consultancy based in Berlin. Let us all welcome Ms. Queiroz.
Oh, thanks so much. Can everyone hear me? I think, yeah, perfect. Yeah, thanks so much for this really lovely introduction. I'm going to start sharing my screen here. I think hopefully you can see my presentation.
Yes,
okay.
we can.
Perfect. Yeah, thank you so much, Mitch, for this really lovely introduction and the very kind words. Good morning to you. I am in Amsterdam, so it's a good afternoon to me. Just first things first, thank you so much for having me and just for giving me the opportunity to present a little bit about my work at this really lovely colloquium. I was actually attending virtually the other two ones, and I learned quite a lot, and it was really lovely to kind of see you guys engaging and asking really important questions. So I hope that you enjoyed this one too. Also, I would just like to note that Ivan is an absolute tax rock star and just an overall incredible person. And you're so very lucky to have him as your teacher. Do enjoy it because it's a privilege. Obviously, I was already introduced, but just by means of a very quick introduction. My name is Luiza. I am and by the way, Mitch nailed my last name. Loved it. Thank you so much. I am a lecturer here at the Free University of Amsterdam, and I'm also a dual PhD candidate here at the VU and at a university in Germany called Hohe University Bochum. And today I will be taking you through one of the chapters of my thesis, which in very broad general lines is about the relationship between the international tax regime and socioeconomic rights realization in developing countries, as Ivan already briefly mentioned. While my thesis is predominantly doctrinal, this chapter that I'm going to be presenting today, which hopefully will be turn into a published paper soon. It's more empirically oriented, and it's centered on the Republic of Kenya as a case study. So I was in Kenya at the end of 2023 doing some field work, and this is kind of the result of that time. In this presentation, I will be speaking of my proposed concept of fiscal constellations, which is this kind of new way of conceiving fiscal rulemaking. By fiscal rulemaking, I mean just, tax policy and legislation making. And more specifically, I will be speaking of essentially how I arrived at this concept and how it allowed me to reach a few conclusions about the extent to which fiscal rulemaking is influenced or not by human rights normativity in Kenya. So that's kind of the outline. So while I am a fan of saving the best for last in most things, there's definitely something to be said about a good spoiler. And so in the name of a good spoiler, let me break down the paper's sort of three main takeaways for you in case you need to leave early, or if you can't make it to the end, here's a snapshot of the three main takeaways. So first of all, the ideal of a fiscal state that is based on the social contract and that is democratically overseen can be severely disrupted by globalization. Now, this is not me saying it. There's a lot of scholarship on this. What I tried to do in the paper is to sort of uncover the very specific mechanisms within the fiscal rulemaking cycle that allowed this disruption to happen. So then the second takeaway is that although taxation is this kind of really multifaceted topic that spans across different legal regimes, levels of governance, disciplinary domains of knowledge, in practice, it's really quite unidimensional. And it mostly revolves around public finance management considerations. And what I mean by this is that while we can probably very easily conceive of this idea that taxation could or should be used as an instrument for human rights realization, at this really high level of abstraction, when we look at it more pragmatically, what happens in practice, we see that tax policy and tax legislation tend to adopt a vocabulary and kind of pursue goals that are more sort of aligned with an economics way of thinking, and particularly with PFM. And then the third takeaway of the paper is that in the Kenyan case, which is specifically what I look at here, the realization of constitutionally protected socioeconomic rights is deprioritized through a three-step process that I will explain in further detail in a bit. Just as a side note, socioeconomic rights, as Ivan already mentioned, we usually call them second-generation rights, so are essentially the right to an adequate living standard of living, right to education, right to health, so on and so forth. So not so much the civil liberties and the kind of negative rights that demand that the state doesn't do something, but the positive rights that actually demand an action towards individuals and groups in society. So those are more the kinds of rights that I'm focusing on. In terms of contributions, I believe that the paper kind of achieves two main things, or it hopes to achieve two main things. First, it sort of puts forward an approach that allows for what I think is a cohesive and constructive synthesis of many themes that are very multidimensional and that are just generally not analyzed together in traditional doctrinal research. And then the second thing that I hope the paper strives to achieve is to apply this approach that I came up with to analyze the Kenyan case and to generate a few interesting insights. Okay, so with that in mind, we may start by sort of initially confronting the fact that, well, taxes are an inescapable reality of life, as I'm sure all of you know. Every single one of us, whether we're workers, consumers, owners, investors, have had or will have to pay taxes somewhere at some point, taxes and death, as they say. And this reality has been really sedimented long time ago, in this widely cited quote by US Justice Wendell Holmes. I'm pretty sure you have come across this at some point in his dissenting opinion in this case. And he essentially says that taxes are what we pay for a civilized society. So in this kind of contractarian view of the fiscal state that most constitutional democracies embrace, there's this kind of tacit assumption. Sometimes it's kind of outspoken, but mostly it's tacit, that common polity goals that are found in constitutional principles, and to a degree by extension, also in constitutionally protected human rights, ultimately guide fiscal rulemaking. And so through this kind of contractarian lens, the allocation of tax burdens, so who pays what tax, how and when, this allocation of tax burdens across social groups and the redistribution of the resources that were pulled together, so obviously what was collected, this is a task that should be strictly carried out in line with constitutional provisions. That's kind of like the tacit assumption. But then again, to what extent can this be true in practice in a highly integrated global economy, such as the one that we live in the 21st century? So that's kind of the background question that animated kind of my incursion into this whole fiscal constellations world, or constellations eventually, that I have been up to here kind of involved with for the past 2 years. Both international tax and human rights scholarship have increasingly emphasized that this contractarian ideal can be severely disrupted by a global market economy, and by also this model of sort of transnational governance that sustains it. And this scholarship has long noted that developing countries are particularly susceptible to having their contractarian relations interfered with. So that's the background story. So far, though, legal research that has looked at this particular intersection has been predominantly, if not entirely, doctrinal. And although their analyses are absolutely vital for this kind of more theoretical understanding of how legal orders, so like the international and the domestic, and regimes, so, you know, kind of constitutional law, tax law, how these kinds of different orders and regimes can come to be intertwined. These studies are really not geared to uncover the specific mechanisms that make up this sort of entanglement possible in practice. We can discuss this kind of like at this very high level of theoretical abstraction, but how does this happen in the real world, in practice, with all the actors that are involved in fiscal rulemaking, kind of taking different stances and so on and so forth. And so at present, we just know very little about how human rights normativity and taxation interact with one another on a practical level, especially from a developing country's perspective. So relatedly, this means that we don't really have a clear picture of this really convoluted relationship that exists between this sort of internationally oriented fiscal rulemaking and the deprioritization of constitutionally protected socioeconomic rights in developing countries, which is what I'm focusing on here. And so my objectives in the paper were essentially 3. So first, my idea here was to sort of revisit those past assumptions about constitutional limits to fiscal rulemaking, and this kind of like long touted trope of sufficient democratic oversight of fiscal rules by regular government structures. So that kind of idea of like, as long as tax is a domestic issue, it's properly covered by, you know, by democracy and the checks and balances and so on and so forth. And then secondly, I also wanted to sort of better understand how the national and the international domains of fiscal rulemaking can come to be interwoven. And I also wanted to highlight how domestic priorities may actually be skewed by transnational forces that have no particular interest in furthering the realization of human rights within a given country. So what I did then was to first engage in empirical legal research to answer the following question that I have here. So how do taxation and human rights interact at the rulemaking and judicial review level? This is a very broad question, and it was intended as so because, as I said, we don't really know much about this. So I was trying to be as encompassing as I could without just being completely, the research being completely meaningless. So it's broad enough, but still malleable enough so I can kind of steer it. A single case study was chosen mostly because it really lends itself very well to kind of generating very detailed insights about complex mechanisms in a real life context. And I chose the Republic of Kenya for three main reasons. First, Kenya is a very established constitutional democracy, and it's got a young transformative constitution. So the Constitution of Kenya is from 2010, so really quite young. It has an extensive Bill of Rights that provides for the full justiciability of these kind of socioeconomic rights. So people can take the government to court if the government doesn't do what it should be doing. Then the second reason for choosing Kenya is that essentially it's highly relevant, both economically and politically speaking, in the region, both in a kind of like more localized in East Africa, but also if we think more broadly, sub-Saharan Africa. It's got great volumes of trade. It's got actually an EU treaty with the EU on trade, treaty with the US as well. And as you all know, I'm sure, great volumes of trade kind of usually mean that there's a lot of double taxation agreements that have been signed to kind of make sure that things are properly taxed. And then thirdly, essentially, Kenya has a sound institutional framework, has an open civic space, and permanent human rights oversight bodies. And what I mean by that is that talking about tax and human rights sometimes is seen as quite sensitive by some people, which I always find quite amusing because I don't think it's sensitive at all. But you need to have a certain degree of kind of like an open civic space, but also mentality to kind of discuss certain things. So this is why I picked Kenya for this particular study. In the context of empirical research, I'm going to just kind of speak very briefly about methodology, but specifically in the context of empirical research, I collected this information, this data, through in-depth semi-structured interviews with senior public officials and representatives of civil society that I conducted myself. I spoke to respondents from all of these institutions, so the Kenya Revenue Authority, the National Commission for Human Rights, the High Court, the Senate, the Parliamentary Budget Office of the Parliament of Kenya, Tax Justice Network Africa, and Katiba Institute, which is an NGO, local NGO that kind of works with strategic litigation and focuses a lot on matters related to socioeconomic rights realization. And then I also attended a public session that was held by the Finance and National Planning Committee when I was in Nairobi. I analyzed the data with the help of Atlas TI, which is this program that I could speak forever about because I didn't know about it before I engaged with this, and then it kind of took over my whole world. And I essentially analyzed the data by recourse to the thematic analysis method. This means that I inductively coded the transcripts of interviews in 2 rounds. So one round of in vivo coding, and then another round of more sort of purposeful axial coding that was centered around finding keywords and expressions that was, and this kind of second round was more relational and kind of like iterative. During the first round, what I did was I took the quotes from transcripts and I preserved them in their sort of entirety. And I didn't really do a lot of interpretation of words or phrases or expressions. But then in the second round, once I had already extracted what I thought were quite important quotes from these interviews, I tried to kind of extract meaning from these quotes in the form of more kind of descriptive words or expressions. So for instance, a quote related to debt management, quote related to constitutional principles, a quote related to politicization of fiscal rulemaking, so on and so forth. And so this kind of second round was really iterative. There was a lot of back and forth, you know, of, okay, is this a theme? Has this been brought up in which context? And like trying to have more of a holistic overview of all these themes that I was kind of gleaning. As a result of my thematic analysis, 108 codes were generated. And by codes, I mean essentially those themes that I gleaned in the second round. And they were all manually arranged based on their kind of contextual proximity in light of the interviews. And I also organized them around 3 clusters that represent the trias politica. So obviously, naturally, the legislature, the judiciary, and the executive. And it's important to say that I did arrange them manually. I didn't kind of like upload them to a magical thing, and then it kind of, that's what it came up with. It was more of a labor of love, sometimes of hating myself, but took me a very long time to arrange that in a way that kind of did justice and makes sense within the context of the interviews. So in the process of arranging the codes, I kind of was trying to make sense of it, and I found that 6 basic interactions were kind of sufficient to account for the relationships that between themes. And so I kind of propose these kind of 6 basic interactions. There is an annex that I just have like a brief explanation of what these basic interactions mean in further detail. I don't think I sent this to Ivan, but if anyone is interested, I'm glad to, or be happy to share it. But quite importantly here, what is really important is that the 6th basic interaction that I propose, which is called broken mechanism. And essentially this interaction was identified whenever I saw that there could be a point of entry for human rights normativity, for this discourse of human rights, for the language of human rights to kind of penetrate this fiscal rulemaking cycle, but that for some reason that was not happening and it was blocked. So once I had these 3 clusters, and I'm sure you can't see anything here. If you can, I don't know, you have superhuman powers, but I hope that you saw it in the document that the annex that Ivan shared with you. But I did come up with these 3 clusters, and once I had them, then a second phase of my analysis began. And I think, perhaps, I don't know, I would like to hear from you if you felt like it was clear in the paper, but if it wasn't, this is me clarifying it, hopefully. I had this whole cycle of empirical research, and then I had this, and then I was like, how do I make sense of this? And I was really trying to make sense of what these themes could possibly tell me about the influence of human rights normativity in fiscal rulemaking in Kenya. And then it struck me, and I realized that sort of a purely descriptive account of broken mechanisms that I had identified would not really yield sort of very interesting insights. It would just be, the analogy that I came up with is that it would just be like getting, say, a sample of water at a river once and stating that that's the quality of water in that river at that specific point in time. It might be important, sure, it is important to have that one kind of sample, but I do feel that it's more important to kind of follow a methodology that allows the quality of the water to be tested frequently under changing conditions, which then sort of enables better interventions in the future. And that's kind of what I thought when I was going through this process myself. The more I looked at the networks that I created, the more I sensed that there was an underlying pattern that was staring at me right in the face, but I couldn't really quite put my finger on it. And so then after a lot of reflection and a lot of reading different things, I realized that properly interpreting these networks and generating some actually really interesting insights would require a degree of abstraction that kind of went beyond mere description. And that's when I came up with the Fiscal Constellations approach. and I named the 3 clusters that I developed fiscal constellations, which again, I find very poetic. The fiscal constellations approach that I propose in the paper essentially consists in interpreting these empirically gathered themes through a social legal lens. And specifically, I argue in the paper that we should look at these thematic networks, the fiscal constellations, as kind of like these new normative sites of exploration of social legal developments in a transnational world. This interpretation, and this is where potentially things get a little bit murky, but it was made possible by some insights that I drew from this idea that was put forward by Piers Umbenson. I don't know if you know this scholar, but he writes a lot about transnational law. And if you have never heard about the concept of transnational law, it essentially means law that doesn't really fall squarely within the traditional definitions of public, private, domestic, international. So we have all these bodies of law and these legal orders, and then there's transnational law, which kind of accounts for this regulatory space that somehow doesn't fit very neatly these kind of more well-defined traditional kind of definitions within doctrine. So this interpretation was essentially me taking some insights from this idea that Piers Umbenson puts forward, that transnational law should be seen as a methodology rather than a body of law per se. And also by some parallels that I draw between the networks and Niklas Luhmann's work on social subsystems theory or social systems theory. Now, one can really go very deeply into the Luhmann rabbit hole. And perhaps we can ask Ivan later about his own journey with Luhmann's work. I can tell you that I had my own experience with it. But what I took from his theory are essentially 2 main aspects. First, that what he describes as social systems, such as law, politics, economics, they're generally autonomous and closed systems that process communications following a particular code and a particular programming. And then the second thing that I took away to kind of apply to my interpretation of my own networks is that there are mechanisms that he himself terms structural couplings that link functioning systems because they have plural meanings in different systems. So he actually specifically mentions taxation and constitution as kind of like 2 mechanisms that sustain plural meanings in different social systems. So obviously you can talk about the Constitution from a legal perspective. You can talk about the Constitution from a political perspective. And, you know, it's kind of like a shared, like a common ground for these non-intersecting closed systems. So I know that this might be a little bit abstract, but the point that I tried to make in the paper is that fiscal constellations essentially contain legally relevant themes that can be seen as kind of like manifestations of transnational law, and that each constellation in this kind of interpretation, when I draw parallels with Luhmann's work, is kind of undergirded by a particular logic, kind of like a program-like logic or rationale that contributes to the ejection of human rights normativity from the fiscal rulemaking process. And so the most important thing is that this kind of joint interpretation allows us to kind of move beyond a more kind of like a simple and fragmented analysis of stellar themes or just of the identified broken mechanisms, and then kind of like that descriptive exercise. And it allows us to arrive instead at a more kind of systemic interpretation of what the constellations represent or what they tell us. So in my proposed approach, fiscal constellations are a visual representation of the many facets of fiscal rulemaking that may enable or constrain human rights realization through different but concomitant mechanisms, so mechanisms that happen at the same time. And so each node or star, in keeping with the poetic nature of all this, represents a theme that is endogenous, to fiscal rulemaking or that exogenously influences it, and that may at the same time obstruct or allow human rights normativity to seep through the process. I define endogenous themes as those that are essentially part and parcel of fiscal rulemaking due to either constitutional mandate or institutional practice of the actors that are traditionally involved in the process. And I define exogenous themes as those that are more kind of generally neglected, ignored, or played down by decision makers, or simply those that are just not an integral part of the decision-making cycle, but that still have an effect on the outcome of this, on the quality of these fiscal rules and the objectives that they pursue. So I give some examples here, just briefly. Examples of endogenous themes that I cataloged. So those that are part and parcel of the fiscal rulemaking process that I cataloged in the Kenyan Constellations are public participation as constitutional requirement. So there is a provision in the Kenyan Constitution that says that any policy, not just fiscal policy, has to undergo public participation before it's enacted and becomes law. I also mentioned the role of the Budget and Appropriations Committee of the National Assembly, which is kind of their House of Representatives, and its role as a policy gatekeeper. That was also something that kind of came through very strongly from the interviews. And I also mentioned the existence of competing institutional interests in the negotiation process of double taxation agreements. So apparently, we tend to think that governments are a monolith, but they're not. Different sections of the government have different interests, and that kind of plays a role. And that was also very well captured in the constellations. And then just briefly, as exogenous themes, I kind of mentioned capacity limitations within the legislature, retaliation to judicial scrutiny, which obviously is not a part of fiscal rulemaking, but also has bearing on it. And they kind of illustrate these types of what I call exogeneity quite well. So looking at each one of them in more detail, we can start with delegation or ratification, which is, again, I'm sorry for how small this is, but again, I hope that you had a look at it before. But essentially, it is made up of 40 themes that reveal aspects that are related to the role of the legislature in fiscal rulemaking. So how the legislature kind of acts in this. And very clearly, this constellation focuses on the overarching themes of budgeting and democratic oversight, which I don't think is surprising. Examples of themes that I have there are parliamentary oversight of domesticated policy, budget-making processes, and clientelism and resource allocation. The rationale that I have identified while kind of like interpreting these themes systemically and their connections to each other is that there's an outsourcing of fiscal rulemaking, especially the tax revenue raising aspect. So not so much the expenditure side. So there's an outsourcing of fiscal rulemaking to specialized bodies and structures due to their mandated or assumed epistemic authority, so kind of knowledge. And this means bodies and committees that possess specialized economic, preferably public finance management knowledge. Within this logic, what happens is that human rights normativity's entry into fiscal rulemaking is restricted because, well, first, outsourcing fiscal rulemaking means that the deliberation over different aims and objectives that fiscal rules can or should pursue are also outsourced to these committees or to these bodies. And so the very process of outsourcing is really overwhelmingly guided by the search for economic expertise, which makes it so that constitutionally protected socioeconomic rights, which was the departing point of this, we have these rights that are protected in the Constitution, they arguably cease to be the focus of fiscal and particularly tax rulemaking. And as they kind of slowly make way for indicators of economic performance and corresponding targets, fiscal rulemaking kind of suffers this really dramatic epistemic shift. So you go from this idea that we should be fulfilling normative values of collective welfare and well-being to kind of this more efficiency-driven rhetoric or discourse, if you will. Also, budget scrutiny is often mediated by the private interests of the few who are actually involved in the budget-making process. That came out quite clearly as well. And last but not least, the possibility of oversight by specialized human rights bodies ends up being severely restricted because of budgetary constraints that are kind of made easier by point number 2 here. So let's just put it this way, people who are involved in this have obviously no interest in having more scrutiny over what they do, and budget allocation to the National Commission for Human Rights, which is one of the oversight bodies, is not the best. So summing up this kind of rationale that I identified, you can see this quote by a civil servant from the Parliamentary Budget Office, which is an independent body constitutionally mandated to assist both houses of parliament in economic and financial matters. And here, this person was speaking of one of these specialized committees, so the Budget and Appropriations Committee, and its role in fiscal rulemaking. So here, what they're saying is that this committee is the gatekeeper of policy in Parliament. And I think that kind of gives you a flavor of this kind of logic of outsourcing, or this rationale of outsourcing that I identified. Then next up, we have influential expertise, which is a constellation constituted of 43 stellar themes that essentially gravitate around the executive's role in fiscal rulemaking. And the focus here lies on themes that concern power dynamics in the international tax and finance regimes, and also on a general view of public participation in rule and policy making as a process. And so the logic that it follows is kind of ultimately one of internationalization, which kind of leaves fiscal rulemaking very susceptible to external power capture, while also externalizing human rights, language, and normativity from the process. And this internationalization logic operates in a way that kind of restricts human rights normativity because, well, first, those interested in fiscal rulemaking who may want to sway its outputs are not, first, necessarily located within the confines of the nation state, and obviously its corresponding democratic jurisdiction. And these parties' interests, usually profit-driven, stand in opposition to the realization of constitutionally protected socioeconomic rights. So essentially, those who are able to sway fiscal rulemaking don't necessarily care about the realization of socioeconomic rights in a given country, in this case, in Kenya. So at the same time, rulemaking that aims for efficiency is largely left unchecked once rules are enacted. So more specifically, according to some respondents that I spoke to, there seems to be no monitoring and evaluation mechanisms in place, either in Parliament or at the Kenya Revenue Authority, KRA, to evaluate the benefit derived from, for example, double taxation agreements or from specific tax incentives. So you aim for efficiency, but then the second step, which would be to see, is this kind of beneficial to us? It's just not there. There are also no human rights impact evaluations for adopted fiscal policy in place. And then finally, the logic of internationalization kind of privileges this ideal of public participation as a process, which is effectively contrary to an ideal of meaningful public participation. I have included here a quote that sums up this rationale, and it's from a representative of civil society who said that the stage, which I would say the Kenyan government is at this point, is that they will engage the public for technical compliance, but in terms of effectiveness, they still go ahead and pass what they want. So yeah, it's a win and a loss at the same time, technical compliance, but with not adequately considering the submissions that people were making, both from private actors as well, but as well, honestly, the public, what do we call the public interest guys? So this is kind of this idea, okay, we have to submit things to public participation. So it's just a formality. It's just a check the box exercise. And then finally, we have the hermeneutics and self-reference constellation, which contains 25 themes that vary from very practical matters, such as the Finance Bill 2023, which was a catalyst for social unrest in the country. And it also covers aspects that concern Kenya's kind of legal architecture more broadly. So, for example, the role of the Supreme Court. Being a constellation of themes that were grouped from the perspective of the legal system, it follows this kind of like self-reference logic that looks inwards to positive law and jurisprudence, so case law, to provide answers to problems, as opposed to empirical knowledge, which, as I'm sure you will know, lawyers are not concerned with the factual reality, let's put it this way. The bread and butter of lawyers is the law itself, not necessarily factual reality or causal links empirically established. Unless this is kind of already in the law, that's not what lawyers concern themselves with. So while judges may, of course, take into account concepts, take into account concepts that are foreign to the law when deciding cases, as a rule, they cannot go beyond what is legally there, what is legally stipulated, right? And obviously that which is argued by litigants. This self-referential rationale, or in this rationale, human rights normativity is prevented from kind of seeping through the fiscal rulemaking process because of, first, a lack of economic knowledge by kind of the general public, which leaves the average person on the street in a difficult position to kind of like judicially challenge fiscal rulemaking that is socially not good for them, right? You have to kind of have a very good understanding of fiscal policy, of competing possibilities and how, I don't know, the economic system works as a whole to be able to kind of challenge that concretely and convincingly. And so relatedly, cases that do end up reaching the judiciary are not really framed through the lens of, these collective socioeconomic rights, but rather through the lens of kind of elites' interests. And when I say elites here, it's more like tax cases that do reach the judiciary. I would risk saying that that's not a Kenya thing. It's a global phenomenon. Usually they speak more of technicalities contained in tax legislation. So not really the broader implications, distributive implications of tax policy. And so lastly, a lack of interdisciplinarity or interdisciplinary knowledge of those that sit on the bench, who are not even, by the way, expected to be substantively ruling in matters of public policy, contributes to this kind of like restriction of human rights normativity. And I have included here a quote from an interview with a High Court judge, which sums up this kind of rationale identified very well. And I really like this quote because I think it's very clear. This judge told me, you see, courts don't go out looking for cases. Cases come to courts. And inevitably, the people who may find these kinds of cases will be the ones who are least interested in socioeconomic rights. And he says, it's a fact. I would want to say it's a fact, but I have no empirical information or data. He was going in that direction. So reaching my main conclusion, because I have spoken quite a lot and I don't want to bore you, I note in the paper that combined, these kind of coexisting types of logic result in what I call a state of tax and human rights stasis, which is this kind of like stable state that is characterized by this shared impression that people have that fiscal rulemaking should be guided by human rights normativity. And here I kind of refer to these constitutional principles and constitutionally protected human rights, but one that is not really commensurate with the actual reality of of how these themes interact within the constellations. Also, a perhaps obvious recommendation that arises from this analysis is that, you know, the realization of socioeconomic rights, human rights, but particularly socioeconomic rights, cannot be an appendix to fiscal rulemaking. You can't just, you know, kind of come up with the fiscal policy and then kind of put a comma at the end and say, oh, and we have to also focus on human rights. That's not how it works. You have to situate the former as the core of the latter, and that requires the adoption of both an interdisciplinary approach to taxation and a radical rethinking of the contractarian model of the fiscal state in the 21st century. And there's a lot of scholarship, or not a lot, but there's some scholarship that is starting to pop out there kind of in that direction. You're going to have a session with Tsili Dagan, if I'm not mistaken. She talks about the social contract. I don't know if she's going to be talking about that, but if she does, you're going to have such a great experience asking her about these things. And just to conclude, just thinking about future research on the intersection between taxation and human rights, I would just like to draw attention to the fact that the fiscal constellations, they may provide a useful starting point for further explorations of these kind of thematic niches, and very importantly, of causal relationships through empirical investigation. So I didn't try to establish any causation here. It was more of an investigative kind of, I don't know, end kind of work of trying to piece pieces of the puzzle together to arrive at something that we can have as a common ground to start discussing this relationship. And so that's it, I guess. Thank you very much for your attention. I hope that this was insightful. And just one thing, this is kind of towards the end, but still, I'm happy to take on board your suggestions. Whatever you felt was not clear, I can try to address it. But yeah, it's kind of like a work in progress kind of situation. So bear that in mind. Thank you.